The Religious Freedom Restoration Act of 1993, Pub. L. Number 103 to 141, 107 Stat 1488, codified at 42 U.S.C. AA millisecond 2000 BB through 42 U.S.C. AA millisecond 2000 BB4, is a 1993 United States federal law aimed at preventing laws that substantially burden a person's free exercise of religion. The bill was introduced by Howard McKeon of California and Dean Gallo of New Jersey on March 11, 1993. The bill was passed by a unanimous U.S. House and a near-unanimous U.S. Senate with 3 dissenting votes and was signed into law by President Bill Clinton. It was held unconstitutional as applied to the states in the City of Boerne v. Flores decision in 1997, which ruled that the RFRA is not a proper exercise of Congress's enforcement power. However, it continues to be applied to the federal government, for instance, in Gonzales v. Centro Espirita Beneficente Uniao do Vegetal, because Congress has broad authority to carve out exemptions from federal laws and regulations that it itself has authorized. In response to City of Boerne v. Flores, some individual states passed state religious freedom restoration acts that apply to state governments and local municipalities. Provisions: this law reinstated the Sherbet test, which was set forth by Sherbet v. Boerne, and Wisconsin v. U.S.C, mandating that strict scrutiny be used when determining whether the Free Exercise Clause of the First Amendment to the United States Constitution, guaranteeing religious freedom, has been violated. In the Religious Freedom Restoration Act, Congress states in its findings that a religiously neutral law can burden a religion just as much as one that was intended to interfere with religion. Therefore the Act states that the AUOE government shall not substantially burden a persona unregistered trademark's exercise of religion even if the burden results from a rule of general applicability. The law provided an exception if 2 conditions are both met. First, the burden must be necessary for the a furtherance of a compelling government interest. Under strict scrutiny, a government interest is compelling when it is more than routine and does more than simply improve government efficiency. A compelling interest relates directly with core constitutional issues. The second condition is that the rule must be the least restrictive way in which to further the government interest. The law, in conjunction with President Bill Clinton's executive order in 1996, provided more security for sacred sites for Native American religious rights. Background and passage. The Religious Freedom Restoration Act applies to all religions, but is most pertinent to Native American religions that are burdened by increasing expansion of government projects onto sacred land. In Native American religion, the land they worship on is very important. Often the particular ceremonies can only take place in certain locations because these locations have special significance. This, along with peyote use, are the main parts of Native American religions that are often left unprotected. The Free Exercise Clause of the First Amendment states that Congress shall not pass laws prohibiting the free exercise of religion. In the 1960s, the Supreme Court interpreted this as banning laws that burdened a person's exercise of religion. Wisconsin v. U.S.C, 406 U.S. 205. But in the 1980s the court began to allow legislation that incidentally prohibited religiously mandatory activities as long as the ban was generally applicable to all citizens. Also, the American Indian Religious Freedom Act, intended to protect the freedoms of tribal religions, was lacking enforcement. This led to the key cases leading up to the RFRA, which were Line v. Northwest Indian Cemetery Protective Association and Employment Division v. Smith, 494 U.S. 872. In Line, the court was unfavorable to sacred land rights. Members of the Yurok, Tolowa and Karok tribes tried to use the First Amendment to prevent a road from being built by the U.S. Forest Service through sacred land. The land that the road would go through consisted of gathering sites for natural resources used in ceremonies and praying sites. The Supreme Court ruled that this was not an adequate legal burden because the government was not coercing or punishing them for their religious beliefs. In Smith, the court upheld the state of Oregon's refusal to give unemployment benefits to 2 Native Americans fired from their jobs at a rehab clinic after testing positive for mescaline, the main psychoactive compound in the peyote cactus, which they used in a religious ceremony. Peyote use has been a common practice in Native American tribes for centuries. It was integrated with Christianity into what is now known as the Native American Church. The Smith decision outraged the public. Many groups came together. Both liberal and conservative groups as well as other groups such as the Christian Legal Society, the American Jewish Congress, the Baptist Joint Committee for Religious Liberty, and the National Association of Evangelicals joined forces to support RFRA, which would reinstate the Sherbet test, overturning laws if they burden a religion. The act, which was Congress's reaction to the Lang and Smith cases, passed the House unanimously and the Senate 97-3 and was signed into law by U.S. President Bill Clinton. Applicability: the RFRA applies to all federal law, and the implementation of that law, whether statutory or otherwise, including any federal statutory law adopted after the RFRA's date of signing unless such law explicitly excludes such application. Challenges and weaknesses. In 1997, part of this act was overturned by the United States Supreme Court. The Roman Catholic Archdiocese of San Antonio wanted to enlarge a church in Boerne, Texas. But a Boerne ordinance protected the building as a historic landmark and did not permit it to be torn down. The church sued, citing RFRA, and in the resulting case, City of Boerne v. Flores, 521 U.S. 507, the Supreme Court struck down the RFRA with respect to its applicability to states, stating that Congress had stepped beyond their power of enforcement provided in the 14th Amendment. In response to the Boerne ruling, Congress passed the Religious Land Use and Institutionalized Persons Act in 2000, which grants special privileges to religious landowners. The act was amended in 2003 to only include the federal government and its entities, such as Puerto Rico and the District of Columbia. A number of states have passed state RFRAs, applying the rule to the laws of their own state, but the Smith case remains the authority in these matters in many states. The constitutionality of RFRA as applied to the federal government was confirmed on February 21, 2006, as the Supreme Court ruled against the government in Gonzales v. Centro Espirita Beneficente Uniao do Vegetal, 546 U.S. 418, which involved the use of an otherwise illegal substance in a religious ceremony, stating that the federal government must show a compelling state interest in restricting religious conduct. Post-Smith, many members of the Native American Church still had issues using peyote in their ceremonies. This led to the Religious Freedom Act amendments in 1994, which state, the use, possession, or transportation of peyote by an Indian for bona fide traditional ceremony purposes in connection with the practice of a traditional Indian religion is lawful, and shall not be prohibited by the United States or any state. No Indian shall be penalized or discriminated against on the basis of such use, possession or transportation. Applications and effects. The Religious Freedom Restoration Act holds the federal government responsible for accepting additional obligations to protect religious exercise. In O'Brien v. Bureau of Prisons, it was found that the RFRA governs the actions of federal officers and agencies and that the RFRA can be applied to internal operations of the federal government. As of 1996, the year before the RFRA was found unconstitutional as applied to states, 337 cases had cited RFRA in its 3-year time range. It was also found that Jewish, Muslim, and Native American religions, which make up only 3% of religious membership in the U.S., make up 18% of the cases involving the free exercise of religion. The Religious Freedom Restoration Act was a cornerstone for tribes challenging the National Forest Service unregistered trademark's plans to permit upgrades to Snow Bowl ski resort. 6 tribes were involved, including the Navajo, Hopi, Havasupai, and Hualapai. The tribes objected on religious grounds to the plans to use reclaimed water. They felt that this risked infecting the tribal members with a host sickness as the water would be from mortuaries and hospitals. They also felt that the reclaimed water would contaminate the plant life used in ceremonies. In August 2008, the Ninth Circuit Court of Appeals rejected their RFRA claim. In the case of Adams v. Commissioner, the United States Tax Court rejected the argument of Priscilla M. Lippincott Adams, who was a devout Quaker. She tried to argue that under the Religious Freedom Restoration Act of 1993, she was exempt from federal income taxes. The U.S. Tax Court rejected her argument and ruled that she was not exempt. The court stated, while petitioners' religious beliefs are substantially burdened by payment of taxes that fund military expenditures, the Supreme Court has established that uniform, mandatory participation in the federal income tax system, irrespective of religious belief, is a compelling governmental interest. In the case of Miller v. Commissioner, the taxpayers objected to the use of Social Security numbers, arguing that such numbers related to the mark of the beast from the Bible. In its decision, the U.S. Court discussed the applicability of the Religious Freedom Restoration Act of 1993, but ruled against the taxpayers. The RFRA figured prominently in oral arguments in the case, Burrell v. Hobby Lobby, heard by the Supreme Court on March 25, 2014. In a 5-4 decision by Justice Alito, the RFRA applies to regulations that govern the activities of closely held for-profit corporations like Hobby Lobby and Conestoga, and closely held private companies cannot be required to cover birth control and contraceptives. 20th Anniversary, a day-long symposium was held at the Newsom in Washington, D.C., on November 7, 2013, to commemorate the 20th anniversary of the Religious Freedom Restoration Act. Restored or endangered? The State of the Free Exercise of Religion in America featured 3 panel discussions and 2 keynote addresses. The first keynote address was from Oliver S. Thomas, the former General Counsel of the Baptist Joint Committee for Religious Liberty and the chair of the diverse OE Coalition for the Free Exercise of Religion in the 1990s that worked for the passage of RFRA. The second was from Douglas Laycock, who was an author of RFRA. His address traced the legal history of RFRA and discussed its impact on current debates, including the contraception mandate and same-sex marriage laws. The panel discussions covered the history and impact of RFRA, religious freedom and the contraceptive mandate of the Affordable Care Act, and current and future challenges to the free exercise of religion in a diverse society. The addresses and panel discussions are all available online, as well as a special downloadable resource with more on RFRA, published by the Baptist Joint Committee. See also, Freedom of Religion in the United States, Notes and References. External links, text of the statute, Unconstitutional Restoration, a Princeton Law Journal article on the history, interpretation, and status of the Act. RFRA history and resources from the Baptist Joint Committee, Baptist Joint Committee page dedicated to Newsom's symposium.